Good afternoon, everyone. Welcome to today's webinar on all things contracting in Germany. We will wait a few seconds, as usual, as people start to come through. Please don't be strangers. Pop into the chat who you are, where you are today. Say hello. As always on these webinars, we'll also be making plenty of time at the back end for questions and answers, which you can put into the Q&A button at the top there on the tool ribbon. So say hello in chat and questions into the Q&A. Still got a few people coming into the room today. Starting to slow down now by the looks of it, which is great. So we're probably in a good shape to get started. So good afternoon all. Welcome to today's webinar. Lunch and Learn with myself, Dan Haslam, where we're going to be focusing on the compliance and legal considerations you should be aware of when businesses are looking to hire workers in Germany. So over the next 45 minutes or so, we'll look at the considerations for companies who are engaging contract workers in Germany. We've got quite a few people joining us from lots of different places today, not just in the UK, but also across Europe. So welcome. And I think no matter where you operate, we all recognise that there's a shortage of available talent across many countries. And so it seems that whilst permanent hiring is down, contractor hiring certainly in certain sectors is on the rise. But as always, and Germany is no exception, there are plenty of legal considerations that we need to think about when businesses are looking at hiring workers. So we'll weave through a number of topics today to try and understand a little bit more about how that works in Germany. So we'll first look at that key topic of worker employment classification, always a hot topic no matter which country we're looking at. We'll then move on to look at how the German authorities are starting now to use AI to help work through misclassification cases. So looking at the online tool that they're looking at using, similar to the ones that we have in the UK. We'll then talk through the various ways that contractors can be engaged. So we'll look at those common solutions of employer of record, agent of record, and we'll have a little bit of a chat around statement of work. We'll then move on to look at the EU Platform Directive, which continues to be an interesting piece of legislation having an impact in Europe, but also looking interestingly at how that interacts with local German law. And then for the last topic, we'll just talk about the use of MSPs, recruitment managed service providers in Germany, and how that can differ and what the approach is in Germany in comparison to some other countries. And then we'll finish off with questions from the audience. So please do submit those questions as we go through today's session. Send them in via the Q&A button, and I'll make sure to leave 15 or 20 minutes or so for us to walk through those at the end. So today's webinar is brought to you by Giant Group. We're a leading contingent workforce management company and been operating for over 30 years. And delighted today to be running this webinar in partnership with Klimt HR, one of Germany's leading specialist law firms for employment law. I'm delighted to welcome our keynote speaker today, Thomas Leichter. Thomas is a partner at Klimt's Munich office and specialises in workforce solutions, cross-border projects, incentives and corporate employment law. So welcome, Thomas. Also great to see my colleague here, Charles Dorr, Sales Director for Giant Global. Charles focuses on helping customers access talent globally and compliantly using Giant's global international payroll capabilities. My name's Dan Haslam. I'm Chief Business Development Officer here at Giant, and I've got the honour of being today's host. So the format is a simple one for today. I will be posing a number of set questions to Thomas and Charles that will allow them to talk through the topics that we have planned for today. And we'll try and give some further insight into the considerations for you when you're thinking about hiring workers based in Germany. And please do submit questions, as I said, via the Q&A function, and we'll get to those at the end of the topics. Great, so let's begin. And firstly, take a look at Germany's approach to worker classification. And obviously in the UK, we're very familiar with this concept, referred often as IR35. But as we know, this concept is not new, and it's the same concept in many different countries. So fascinating to hear from Thomas today on how workers can be engaged and operate in Germany. So Thomas, over to you. Please talk us through the approach of worker misclassification in Germany.
Thank you, Dan. So, hello from my side. The starting point is what is an employee and what is an independent contractor. In contrast to employees, independent contractors are not personally dependent in their work. An employee, therefore, is any person working for another person in personal dependence, and this work is based on a contract which is subject to private law. The crucial criteria for an employment relationship are the personal dependence on directives regarding place, time, and specifics of the work performed, as well as the integration into the operating organization of a third party. The following points in particular indicate a personal dependency and therefore argue for an employment relationship. Dependence on directives regarding the place of work, dependence on directives regarding the working time, in particular, beginning of working time, when breaks can be taken, and the end of the working time, integration into the operation of a third party, and no entrepreneurial behavior at the market. This criterion is the relevant one for the Federal Social Court, so very important. For the delimitation of employee and independent contractor, the actual implementation of the contractual relationship is crucial. The term of the contract and the desired legal consequences are not decisive factor, but the content and its practical execution. That means if the contract made by the parties and the practical execution conflict with each other, the practical execution of the contractual relationship prevails in any case.
Great. Okay. So obviously some similar concepts there, Thomas, in terms of the things that you think about in Germany and the same, similar to the UK there. So it'd be interesting to sort of, if you can bring this to life a little bit by talking us through any real life examples that you've seen that kind of illustrate some of these points to the audience when they're figuring out worker classification.
Mm-hmm. So as a starting point, the criteria for self-employment regarding Social Security law are very vague. We do not have a comprehensive list of criteria, and that makes it quite difficult to assess the status of a worker. The authorities and courts decide on the status on the basis of all characteristics of the individual case. And that means if the freelancer, for example, is paid on a time and material basis, authorities and courts argue that this is similar to the payment of an employee. So this is an indication for a dependent employment relationship. And what we have seen in the past years is that the wider the employment relationships become. So from a traditional employment relationship, we have developments regarding a lot of part-time, fixed-term contracts, mini-jobbers, remote work, work from home, and so on. And the more we see this, the more flexible employment relationships become, the more difficult it is to argue this is an independent contractor relationship. Because in particular, the authorities argue if something is done by an employee, or at least can be done by an employee, then this should be an argument for a dependent employment relationship. It was mentioned in the industry that the German pension insurance engaged contractors for artificial intelligence support. And that is an interesting point, because the authority, they do not have the know-how to implement an AI solution. So they asked external workforce to take care of this. And what was brought into the industry was that there were some criteria that usually argue for a dependent employment relationship. So the contractors should have relatively long assignment periods of about 3 to 4 years. They were paid on time and material basis, and they received equipment from the German pension insurance. So usually the German pension insurance would say, if they assess a status of a contractor, these are criteria for an employment relationship, and therefore the status is a dependent employee. When they were asked about the status of the respective workers, they said, yeah, in this individual case, those people were independent contractors.
A wiry smile has just appeared on your face there, Thomas, which is just a smell of irony here. So just to be clear to everybody, the authority in Germany that looks at misclassification is the German pension insurance body. That body is built in, or has built, a AI-enabled tool to work through misclassification, and have happened to hire contractors in order to help them put that together. And there's some interesting observation as to whether or not those contractors should be treated as employees or not. And the reality is, as far as the German pension authority is concerned, they're being viewed as not employees. Whereas, as we know, I think, and as you were saying pre-call, it's often very difficult to get a decision out of the German pension authority that says that someone is anything other than an employee. So it's very interesting. So I think it'd be great for the audience to hear a little bit more then about this tool that the authorities are working on, and how that's shaping up.
Yeah. So up to now, the German pension insurance audits companies by their standard human workforce. They have limited capacities, so they try to get support from artificial intelligence, and that's why they want to create an artificial intelligence that supports risk-oriented employer audits, and they call it KIRA. Though this artificial intelligence shall conduct a pre-selection process. That means the software scans all digitally available data from companies, searches for patterns, and identifies anomalies such as unusually high or low contributions, missing evidence, and the artificial intelligence marks the documents where the anomalies are found. Then, in a next step, the auditors can decide which cases they would like to audit directly. That means artificial intelligence shall support the auditors to see which cases are critical and need to be audited directly.
Okay, that sounds pretty self-explanatory and a sensible approach. So effectively, they've got the AI working on the case to look at cases and trying to say, yeah, these are clearly employees, these are clearly not, and then direct the human to look at the ones in the middle that are a little bit more tricky to define, to try and speed up the workflow, which I suppose in principle is definitely a good objective. But I do wonder if there are any concerns around that process from a sort of data protection GDPR perspective, or, from your perspective as a lawyer, label, looking at the procedures here and the risks around it when the DRV are using AI trained to sort of figure out on these data sets. Are there any particular concerns there, or is there any particular documentation that companies should be looking at to retain and show that they're making good misclassification decisions?
Yeah, as always, where there is data, there are some concerns. What we have in Germany are electronically supported tax audits. That means the companies need to transmit electronically the data to the authorities. And there is a system-approved payroll accounting program, and the electronic transmission of data from financial accounting is mandatory. So the companies need to forward the relevant data to the authorities. However, sorry, there are some exceptions. At the employer's request, electronic transmission of audit-relevant data may be waived for periods up to the end of 2026. The request must be sent informally, stating the company number, sent to the pension insurance institution responsible for the company audit, and that's it. Yeah, then you do not need to do this until the end of 2026. When you provide the authority with the data, the data will only be used for this specific process, and you get an electronic receipt of acceptance. So there should be no data concerns regarding this process. It is mandatory. There are some exceptions until the end of 2026, but then all companies need to follow this process.
Okay, so they seem to have considered and given people some comfort that the information's being passed in a secured way, and it's not going to be used for any other reason other than the misclassification. How do you see this playing out then, Thomas? Do you think the reality is that the authorities' use of AI is going to speed this process up or change the volume and profile of these cases? How do you see this playing out?
At least that is what the German pension insurance intends. They wanted to implement it in 2025, but at the moment they haven't. They are still checking it, and the latest update was that they would like to implement it in 2026. So in some months' time, we will see whether it will really help.
Yeah, good. But again, I think we're used to the concept of having a check employment status test tool, as we call it in the UK. Interesting to now hear another country developing a similar sort of process, because the reality is that many governments just want to get through the processing of these cases to effectively be able to increase the tax take where it's appropriate. So I think it's just at a high level, this is indicative of the fact that many governments are just looking at more and more at misclassification as an area to make sure they can be as clear as possible to increase the tax take for their country. So thanks, Thomas. It's fascinating to hear how that is progressing. In terms of how a company can reduce their risk then, so some practical suggestions as to how companies can reduce risk on this topic. What would you say to the audience in terms of takeaways for them to think about how they can avoid a misclassification case?
So if we speak about a contingent workforce compliance system, the starting point is always proper contracts. The contracts should be drafted in a way that they imply an independent contractor relationship. So no terms regarding employee-employer support, help. It should be proper contracts for an independent contractor, and that's what we see in practice quite often is not followed. There are a lot of contracts out there that have a lot of indications for a dependent employment relationship, and that is difficult. And this will become more difficult if the authority will use artificial intelligence, because that will be checked and then it will be seen. And if the contracts are not proper, in most of the cases, that's the end point, because the authorities would then say, we have some indications in the contract that argue for a dependent employment relationship, therefore it's worker misclassification, and then you are in the process. If you have proper contracts, then please take care of the practical implementation. As said at the beginning, if practical implementation and contract deviate from each other, the practical implementation prevails. And what we've seen is there are a lot of criteria. We will not discuss all, but please take care of some of the following points. The contractor should ideally employ an employee. That is a very good criterion to show that this person is an independent contractor, because an employee does not engage an own employee to support the specific services. In addition to the client, the contractor should also work for other clients and advertise on the market, so that the contractor shows I'm taking an entrepreneurial risk. I'm marketing my services. The contractor should only use its own equipment to carry out the work, because the dependent employee gets the equipment from his employer. The contractor should have their own email address, business cards, phone numbers, with no connection to the client. We still see this, that the email address, the email signature is the same as the signatures and email addresses of the internal staff. At least insert external or ext in the email address. The contractor should work in its own facilities. Ideally, the contractor has own offices, rented space, also to show I'm taking entrepreneurial risk. And then, of course, no directives, no monitoring. These are just some examples, but that's important to check how the practical execution of the contract is done. This can be done under a compliance system, and there is an option, an official option to get the status of a worker checked in front of the German pension insurance. It's called status inquiry proceeding. That means the contractor and or the client can ask the German pension insurance to check the status of the worker. This can be a good idea in some cases, but it should be checked in each individual case whether this is really a good idea. Because if you inform the pension insurance, the authority, we have doubts that this is a true independent contract relationship, it could be that they say yes, and the doubts are correct. You are not an independent contractor, you are a dependent worker.
Yeah, tread carefully on that. Then I suppose you're just highlighting there's the opportunity to get clarification from the pension authority, but if you get that wrong, you're almost waving at them to say, yes, we'd like you to come and take more social security from us, basically. So take some advice on that maybe before you make that step. And I think you've made some great points there, Thomas, just in terms of contracts can be drafted however anybody wants to draft a contract, but the reality has always got to be that the working practices marry up to the essence of that contract. And I think you said, if there is a case, it's going to be the actual working practices, what is happening on the ground, that the authorities will look at, aside from just simply reading what a contract can say, because I'm sure a good lawyer like you can make a contract say most anything, to be fair. Great. That makes complete sense. Just a reminder to everybody, if you've got any questions, please do put them into the Q&A function and we'll get round to those with Thomas and Charles at the end of the topic. So thanks for now, Thomas. Charles, it'd be great if we could bring you in here a little bit. If you can just give us your view, basically, or an overview of how workers can be engaged by companies and the sorts of suppliers that are out there in the market that can help companies access contractor talent.
Yeah, for sure. So probably useful to outline to the audience the type of providers and solutions in the marketplace that provide EOR and AOR services like we do here at Giant, and how they can help to engage workers. So an EOR service is an employed option. So the worker would have an employment contract, could be open-ended, it might be fixed term, but each month there'll be a payroll run. The worker would receive a net pay along with a payslip. All taxes would be deducted at source. All employer costs would be paid directly to the local authorities, and the worker is then able to focus on their work while, I guess, all of the admin associated with being paid is taken care of for them. Something specifically for Germany to consider, though, is, and I'm sure Thomas can correct me if I am wrong, but hopefully I'm still correct in my knowledge. I think the longest that you can engage with a worker under an AUG license is 18 months, at the end of which time you then need to have a 3-month gap before you can then re-engage that worker again on the same project, or you have to completely re-resource. So EOR employed in Germany for contingent workers is absolutely possible, but you do have some time limits on there. And then, as we've touched on earlier, the other way to engage is through an AOR service, agent of record, where the worker or the contractor would be working as a self-employed or a limited company. Now, with this solution, the worker would receive a gross payment, and it would be part of their responsibilities to pay their taxes and social securities directly to the authorities. And so again, as Thomas was alluding to, though, there are a number of criteria that you do need to consider as to whether an AOR engagement is correct for a particular worker or not. And again, I think one of the stats that I remember is that I think it's no more than 83.33% or 5/6 of your income is meant to come from one client to be officially considered a freelancer in Germany. So, and again, there were a number of other points that Thomas highlighted as well. But AOR is completely possible as long as you're meeting those criteria. And there are other forms of engagement, but often we use just EOR or AOR as a bit of a catch-all. But you could have company-to-company engagement. You could have someone in Germany who's actually got their own GmbH, as opposed to just the freelancer or Freiberufler setup. And then, of course, you can have workers who are directly sourced by an end client or subcontracted or consultancy agreements. So there are a number of different flavors there. But as I say, generally, we try to use EOR or AOR as a catch-all for everything.
Charles, I think you're getting top marks from Thomas. He was nodding away to all the points that you were saying there in terms of timings, and I was also impressed with your pronunciation of that German term. I would not want to have copied it myself. So full marks to you there, sir. Well done. Thomas, do you want to come in on that topic as well? Any comments that you've got around worker engagement types, or any views for the audience?
Yeah, just in addition to everything that Charles said, that was absolutely correct. So independent contractors, you can use individual natural persons or contractors that have their own limited company. The pros are you have access to specialized skills. It's flexible, no need to provide benefits, pensions, sickness payments, whatever. The negative side is you have less control over the contractors. There can be risks related to confidentiality and intellectual property. And of course, it's a high organizational and legal effort regarding compliance. You could then say, okay, we do not use independent contractors, we use IEG workers. Yeah, the good thing is you have workforce flexibility. There is a reduced administrative burden because the agency handles payroll. The cons are you have to pay fees to the agency. It's highly regulated. And as Charles said, we have assignment limits, in general 18 months. And we have principles of equal pay and equal treatment. So you can also have a lot of issues when using dependent employees as IEG workers. EOR, as Charles said, proper business model in a lot of countries, but you have to be familiar with the specifics. We've advised EOR providers on their global expansion, and there are in each country a lot of differences, although the basic principles might be similar. So you should check each individual country. And then we have a lot of other types like service contract, statement of works, so consultancy services. What we see in practice is that one of the most relevant points is please ensure that you have a proper and comprehensive service description. Because if you do not have the right service description, the parties do not know what to do. Liability is an issue. Risk of worker misclassification is an issue. So service description is key.
Yeah, great, understood. I suppose the other thing to layer in there, and when we've talked about pros and cons of different worker types, the other big one, of course, is cost, isn't it? So we know that's fundamentally one of the reasons why companies are tempted to try and engage workers as not as employees, because when they are employed, there's of course all the employment costs associated. So it's often that commercial consideration on the cost of delivery that drives these models. And absolutely, if someone is looking at building an SOW, statement of work arrangement, then the more defined those deliverables are, then the more it would certainly look like a proper project, which helps from a compliance perspective, but also helps define the scope of the project and obviously the cost associated. So that makes total sense. Okay, so let's leave that topic now and move on to the next one, which was the EU Platform Directive. So we've heard quite a bit now about the Platform Directive on a number of these webinars that we've done across Europe. So it'll be interesting, Thomas, just to hear from you how this directive is interacting with local German law. Obviously, the directive sets out an EU level sort of framework, but the actual implementation of the directive is done at a national level. So what's going on that from a German perspective?
Mm-hmm. So I do not want to talk a lot about the general topics of the directive. Here in our webinar today, it's relevant that one of the key objectives of the directive is to ensure the correct classification of the status of platform workers and to reduce worker misclassification. Regarding the employment status of the workers, the directive includes a presumption of an employment relationship, and that is critical. So they say if someone works for a platform, there is a presumption that this is an employment relationship.
Okay.
So you need to show that there are factors that this is an independent contractor relationship, and this will now be part of the local laws. How can you show that the worker is an independent contractor? You might remember there was a little discussion when the directive was discussed. There were in the first draft there were some criteria. If some of them were met, then that this argues for a dependent employment relationship. This is done now. It's relatively vague at the moment. So the member states shall ensure that a contractor is a true contractor and the dependent worker is an employee. So the key question is, what is a worker? It's not defined in the directive, and the directive says the member states need to determine what is a worker. And what we see, the terms control and direction, which are mentioned in Article 5 for the legal presumption, which are mainly used to examine whether a worker may be considered as an employee, will allow different interpretations in the various countries. So it's not clear. What does control and direction mean in the UK, in Germany? And therefore, you need to have a look at the local law later, how this is used. That's difficult because it's a European directive, so it would be good to have a European definition, but this will not happen. So the definition of the worker will still be national law. Regarding Germany, the question will be whether there will be fundamental changes in determining the status of a worker. In January 2025, we had a new coalition, and they stated in their coalition agreement that the so-called status inquiry proceeding, which we discussed some minutes ago, should be updated. Up to now, it's not clear what will happen. What we heard from politicians is that there will be changes, but the changes will not be that fundamental. So it will not really help. And it's also not clarified whether the definition of digital labor platform only includes the typical industries like taxi and delivery services, or if it contains a broader market and would therefore significantly increase the scope of application. At the moment, the term is relatively wide, and that now is a question of the national legislator, how to define digital labor platform. So a lot of open questions. Please ensure that you have a look at your key markets, because although it's based on a European directive, there will be differences in each country.
Yeah, no, fascinating. And I think, the point you're making there about what qualifies as a digital platform, I think we're all becoming more and more familiar with gig workers and, people like Uber drivers or delivery people that are working on these platforms. But of course, there are a lot of recruitment enabling platforms that are out there now that can give businesses access to a whole host of different types of workers, not just delivery or drivers, but also a lot of white collar type workers. So it's interesting that the presumption is, if someone is working through a platform, and obviously it needs to be defined a little bit more clearer, that those people are employed. That's probably a good starting point for anyone to be taking a risk-averse approach, is think, well, okay, why aren't these people that were engaged in employees, and build a case around it. So I know for sure from speaking to people across Europe, but also in the US, the use of these platforms is becoming more and more prevalent by companies. So they obviously need to pay attention to the misclassification echoes or misclassification challenges that they can bring. So fascinating as always. We're going to move on to our final topic now, which is the use of MSP models in Germany. But before we move on, just again, a quick reminder, I can see some questions queuing up now in the Q&A, which is great. Please do get those in. And then once we finish this last topic, we can then get stuck into those questions for Charles and for Thomas. So Charles, it'd be great if you could come in here and just tell us a little bit more about how that familiar concept of a recruitment managed service provider, or MSP, is sort of viewed in Germany in comparison to other countries like the UK, whether it's easier or more difficult to implement, for sure.
Yeah, no problem. So, absolutely, yes, there are MSP arrangements in Germany. They do exist there, but they do face kind of legal, um, regulatory, and practical complexities in implementing them. It's not let's say, an easy process to go through. Does require kind of careful planning, compliance, and local expertise. I would say, though, that Germany does have a significant contingent workforce, and many global companies do run MSP programs there. I think just to highlight the key sort of challenges or regulatory constraints that they have to address are around the temporary work laws, the AUG license. I think, as Thomas mentioned earlier, the equal pay rights that employed workers are entitled to after a certain tenure. You do have licensing and permit regulations for staffing agencies. There's the complexity around employment law, and the work council's co-determination within Germany. And then you've just got the fundamental kind of tax, social security, payroll compliance piece. So yeah, it goes beyond just the calculation of a gross pay to a net pay. There are all these extra kind of licensing and regulatory areas that need to be considered as well.
Yeah, pretty complex in terms of the factors to think about. Thanks, Charles. Thomas, in your view, MSP arrangements, can they work in Germany or not?
Yeah, definitely. And we've advised on a lot of MSP arrangements in the last 15 years. It's not that popular as in the UK or in the US, but there are quite a lot of MSP arrangements. You have to be careful because the traditional structure of an MSP does not work in Germany. In the traditional MSP structure, the managed service provider agrees and signs the contracts with the suppliers. This will not work in Germany if AUG workers shall be placed, because we have a ban on chain leasing. That means we need to have a direct contractual relationship between the end client and the supplier. However, there are solutions, and this is a fundamental legal difference. So the MSP agrees and signs the contracts on behalf of the end client or on behalf of the suppliers. Because then there is a direct contractual relationship between the end client and the supplier. So from a legal point of view, it's a fundamental difference. The MSP does not agree and sign on its own, but on behalf of the end client or the suppliers. But from a practical point of view, and that's relevant, it's no big issue because the MSP signs, but on behalf of a third party. That's it. And what you have to take in mind is regarding MSP structures, if there is the payment line, this could be subject to the Payment Service Directive. In Germany, we have a specific law called ZAG, and that could be that you require a specific license from the German BaFin, but that's very detailed. Just keep this in mind. There are some differences in Germany, but there are, of course, ways to work with it. So MSP does definitely work in Germany.
Yeah, good. Strong message there. And I suppose, yeah, fundamentally, an MSP is there for a number of reasons, but often to administer and make the operational use of temporary labour more easier. So great to hear that that's not precluded from being done in Germany. You just have to think through a little bit more the legal piece and make sure that's aligned, and then away you go, and you can have all the benefits that are associated with that. So fascinating. Thank you, Charles. Thanks, Thomas, for navigating us through the topics. That brings us to an end of that part of today's session. So as promised, let's get stuck into the Q&A, and pleased to see we've got plenty of questions as always coming through. So If you bear with me, let's just work through those as they've come in, and we'll see any that we don't get to. We'll of course be able to share a response back at the end of today's session. So let's have a look here. So first question I can see from Cara: other than self-employed and limited companies for working as an AOR independent contractor, are there any other employment solutions we can use, similar to the umbrella company solution for working in the UK, etc.? As I understand, this may not be an option for operating in Germany. So, Charles, given your leading on EOR there, that would be a good question for you to pick up first.
Yeah, for sure. So essentially, yes, there is the employed option. So you can have an employer of record in Germany who can provide that employment solution. But the key part of it is that they need to hold the AUG labour leasing license. And as Thomas was just saying, there are some, I guess, restrictions or legislative points around how that AUG license needs to work, the number of people within the contract chain. But there is that option there. But you do have to have that tight contract chain. I think I'm correct in saying, again, it's a maximum of 3 parties. You should have the end client, the AUG license holder, and the worker. So it should just be those 3 parties within that contract chain, and then it's completely possible to operate the employer of record solution.
Yeah, good. Okay, let's move on to the next one then. So one for you, Thomas. Does the use of AI tools in candidate sourcing or classification create any compliance challenges? So this is interesting because this then feeds, it's the topic of AI, but it feeds a little bit into that EU Platform Directive piece there, where we're talking about the use of platforms. So do you see the use of AI tools in candidate sourcing or classification creating any compliance challenges?
Yeah, so in general, as Charles mentioned regarding MSP, if you have a works council in Germany, they will be alerted. So it could be that you have some pushback from the works council. Also with respect to candidate sourcing, then what you definitely need to keep in mind is you might use AI tools, but the end decision must be made by a human being. And what we all know how AI works. Yeah, it can help, but it can also be very creative. And so it could happen that that an application is no longer processed due to a criterion that could be discriminating. So you should definitely be aware of that. If you use an AI tool and there is a discrimination, you can't say, yeah, but that was the AI. You are responsible for that.
Yeah.
So there are definitely compliance challenges, yes.
Yeah, and I'm going to this is off topic a little bit, but even having AI involved in making recruitment decisions, as we know, there are some challenges legally around that as well that governments are starting to think through. So there's certainly many areas of compliance risk once we start to bring AI into it. And as we all know, AI does not like to say it doesn't know. It'll always give you an answer whether it's right or wrong, which is easy to catch you out. Okay, so next question from Abby. Afternoon, Abby. What are the best tools for checking worker classification? Thomas, would you suggest the pension authority, the German pension authority, is the best tool to check? AI enabled pension tool?
No. So what can be helpful is if you can get access to the request lists that the German pension insurance uses. So you can have a look at the questions that they would like to have answered. So that can help. But some of the questions are misleading and they are not comprehensive. So that will definitely not be the best tool. To be honest, there are no best tools. Yeah, and even I prepared a compliance system together with AppSco and freelance.de. I prepared checklists. I set up compliance systems for a lot of clients. At the end, I cannot say that there is a best tool to help. At the end, it definitely needs to be a tailor-made compliance system for each company, because there are differences. And so there are some basic structures that a compliance system should have, but it definitely needs to be tailored to the specific needs of a company.
Yeah, understood. Good advice. A question from Bridget. So Bridget's question is, how do I understand, or how to understand, if a contractor is correctly classified if he is actually working from abroad as a freelancer or contractor for a company in Germany? Okay, so I think the question from Bridget here is, if we've got a contractor who's not based in Germany, but is working for a company or client based in Germany, how would she be able to understand if the contractor is correctly classified? Well, I suppose it would be based on the rules in the particular country where the work is being done. But I'm not the lawyer. Thomas is. So over to you, Thomas. What would you say?
Yeah, so you have to check with respect to which law. Social Security, it's the country where the work is done. And that's the most relevant here. So when we have such inquiries, we ask, okay, the client is in Germany, the worker is providing the services in which country? And then we say, okay, the risk for Germany could be relatively low, but there could be a risk in the country where the services are provided. The next question that we face is, where are the services provided? If you're talking about digital work, is it where the worker is sitting at a computer, or is it where the client receives the work? So most of the people say it's where the worker is doing the work. And then we need to check this local law. What are the criteria in this country for worker misclassification? Because the risk that the German authorities would check the status of this worker is lower than if the worker would be in Germany. Why? Because if it's worker misclassification in, for example, Tahiti, the German pension insurance could not ask to pay social security contributions in Germany. So they would support the authorities, the local authorities. And since they do not have capacities, they will not do it. So the risk in Germany is lower, but you need to check the local laws, whether there is, or how strong the risk of worker misclassification is there.
Understood. Thank you. Charles, one for you. We've got a question from Hafsa. Are there any specific licenses or registrations required for foreign recruitment firms to operate in the German market? I think you touched on this in that last section there.
Yes, so actually, I might need Thomas to help me on that. I was fully aware of the AUG license for the EOR providers, and I believe there is a license for recruiters or the staffing companies as well. But actually, maybe Thomas could just confirm on that.
Yeah, so if you do employee leasing under the AUG, you need the AUG license. Yes, that's correct. But for other recruitment services like contracting, there is no specific license. Yeah, it depends on the specific services. For example, MSP, it could be a BaFin license required, but for the general services in the recruitment industry, the most relevant one is the AUG license.
Okay. Very good.
So only really required if you're doing the employment as well.
Yeah.
If you're just working as a recruiter, just doing sourcing and then using an outsourced company to do the employment, then no need.
Okay, good. That makes sense. Question, a couple of questions from Lorraine. So Lorraine asked, where there's a genuine relationship of a contractor, are there any limitations or things to be aware of when it comes to payroll taxation operated from the UK? So I think we've probably answered that question in the way that we answered the last one there about contractors doing work delivered into Germany. It's going to be, as Thomas said, you'll have to pay attention to the social security tax laws in the UK in that example, Lorraine. Your second question then, we work for customers where there are data security issues preventing contractors using their own laptops and equipment. Is this accepted by the German authorities? So I think this comes back to some of your flags you were raising, Thomas, in terms of indicators of whether someone's operating employed or not, and a contractor using their own equipment would be one. However, in Lorraine's case, she can't do that because of the security issues there. They have to provide the laptops. Would the German authorities accept that?
In general, the independent contractor should use its own equipment. However, in some exceptional cases, it's okay if equipment is provided, but there needs to be an urgent, a compelling reason for doing so, and not, oh, we have laptops for our external workforce. Use this because it might be easier. That is not a compelling reason. But on the other hand, yeah, contractors can also work for military services. You will not bring your own equipment to a military service. Yeah, and then please, if you have the discussion about why it's necessary that the end client provides equipment, please check each equipment that shall be provided to the contractor. Yeah, it could be that a laptop is fine, but that a specific software is not fine, because that can also be provided by the contractor. And then if you think it's required, please make a note why it's required, because it could be that some months or years later you need to argue why there was equipment provided by the client, and if you then have a reason, that might definitely help.
So document the rationale, but in essence it could be acceptable. Okay. Question from Patrick, is there a dedicated recommended tool for AOR determinations in Germany? Well, as we've discussed, Patrick, there's obviously a tool available from the German Pension Authority that could be used. It's a starting point. There's a list of questions there. I think, Charles, when you're looking at misclassification, you also have a questionnaire that you follow on for AOR determinations.
Yeah, absolutely. We have put together a questionnaire, one that is to be completed by the end client, and one to be completed by the worker themselves, to try and get a good steer on if someone should be or would be classified as an independent contractor. And we used the AUG legislation, so we used those questions that Thomas was referring to. We actually combined those with the WAB legislation in the Netherlands, and then also IR35 here in the UK, and also some worker misclassification legislation from the US. So we kind of took a flavour from around the world, and then really drew out the themes that were very similar in a lot of countries, to try and get some general guidance that we could provide to people. But yeah, I mean, it very much comes back to that kind of supervision, direction and control that we hear about all the time in the UK. It's very much along those sorts of themes. So there are tools out there that you can use, but I guess ultimately, again, as we've mentioned throughout the webinar, it's the practicalities that the authorities will look at the end. So you could have your questions answered completely correctly by all parties, and you think that you have a true independent contractor. But if there was an investigation, the authorities will go onto site and look at what's happening day to day, and ask questions of the people who are actually on site. So, if you answer a question, say, yes, I'm completely independent, I set my own hours and I use my own equipment, and you answer everything correctly, they'll actually look at what happens day to day. as opposed to the answers on the questionnaire. So they can only ever give a guide and advise you on best possible practice.
Brilliant. Thank you, Charles. So there's still a few other questions, but we're at time now, unfortunately. So what we'll do is we'll circulate those questions amongst Charles and Thomas and get some views, and we'll make sure on the follow-up to today's session, we'll send the answers out to those. Charles, thanks for joining me. Thomas, great to have you on as always. Thank you to everybody in the audience who came on today. Hope you found that useful. As I say, we'll follow up with the recording and those unanswered questions. And it just remains for me to say, enjoy the rest of your week. Thank you, everyone.
Bye-bye.
Thank you.